Salami to dismiss the suit filed before the Presidential Election Petition Tribunal by the Congress for Progressive Change, the CPC. The appellants insisted that the petition ought to have been dismissed, considering that it was filed on a Sunday, even as it enumerated 7 legal grounds it said should be considered by the Apex Court with a view to discovering that the President of the Appeal Court, Justice Salami, erred in law. But in its ruling, the 5-man panel led by Justice Walter Onoge all agreed that the petition fell short of the 60 days stipulated in the Constitution for an appeal rising from an election petition matter to come before the court. The Supreme Court also dismissed the submission by the People's Democratic Party to take into consideration the annual vacation period of the courts in deciding on the 60 days. The court ruled that considering the matter would only be an exercise in futility, since the constitutional provision has made provision for the time limit within which an appeal in an election matter should be filed. It therefore struck out both the appeal of President Goodluck Jonathan and the People's Democratic Party. The PDP had on the 6th of July pleaded with the 5-man panel of justices presiding over the presidential election petition to terminate the suit filed before it by the CPC, contending that it was smuggled into the court registry on Sunday, the 8th of May. An action, it said, rendered the suit of no effect. The parties to the suit will now await the judgment of the presidential election on or before Friday, the 4th of November.
The Constitution 2857 says you must determine an appeal within 60 days. Now, the court was on vacation for virtually the whole of August and part of September. We cited the decision of the Supreme Court that you have to interpret the provisions of the Constitution as a whole, because that same Constitution has restored the rights of the parties. But the Supreme Court, in their ruling this morning, was of the view that that provision that you must hear the appeal within 60 days is not permissive, it's not discretionary, and it is mandatory. So what it means is that even if you have done all you ought to do, and it's not the fault of the litigant, you will be caught by the 60 days.
We raise objection that 60 days has elapsed. So if it has elapsed, there was no basis of sending this matter back to the lower court to hear it. Or they too exercising a jurisdiction to hear it because 60 days has elapsed. And that was what the Supreme Court agreed on. I think it is very good for our system because it's good for the National Assembly, it's good for the politicians, it's good for the lawyers, and it's good for everybody. So that we now know how to combat this time limit within which to deal with election matters in Nigeria. Both appeals